And I see that the platform is telling us that the meeting recording is in progress. Um, Good morning. This hearing of the New Mexico Department of Health will now come to order. I would like to welcome you to the public hearing on the proposed amendments to 7.3.2.7 NMAC, 7.34.2.8 NMAC, and 7.34.3 NMAC. My name is Craig Erickson, and I have been appointed by Dr. David Scracy, Acting Cabinet Secretary, to act as the hearing officer in this matter, and I will be presiding over the hearing today. Assistant General Counsel for the Department of Health, Crid Woodward, is also participating, and I will be presiding over the hearing. Also participating from the department is Dr. Dominic Cirillo, who's part of the Medical Cannabis Program. And I understand that Andrea Sundberg is going to be a co-host to help us with the public comments. Is that correct, Ms. Sundberg?
Yes, Mr. Erickson, that is correct.
Okay. Pursuant to notice, this matter is being heard this 12th day of November 2021 via Cisco WebEx Online and via telephone. Pursuant to notice, the public has been given the opportunity to comment on the proposed rule via Cisco WebEx and telephonically, and the opportunity was also given to the public to submit written comments via email messages, and they may be submitted through the close of business today. This is a recorded proceeding. We are learning from experience how to get the best recording we can obtain from the Cisco WebEx platform. You can assist with that effort by being having your system on mute at all times, except when you are speaking. In addition, you should turn off your video again unless you are speaking. This is important for the recording. It's also important for the ability of all of us to hear clearly each person who speaks during the course of the hearing. If too many people have their video on or are unmuted, the voice of the speaker will likely become garbled and broken. The time is approximately 9:02 a.m. This proceeding is being held in accordance with NMSA 9-7-6C of the Department of Health Act and NMSA Section 24-14A-1 of the Health Information System Act. And in particular, rulemaking authority is provided by NMSA Section 24-14A-3D5 and 24-14A-5. This rule promulgation process is also governed by the default procedural rule for rulemaking found at 1.24.25 NMAC. We have a number of participants in the proceeding today, as indicated on your screen. Well, we'll proceed with the hearing in the following manner. Dr. Cirillo will give a brief introduction regarding the proposed rule amendments. Mr. Woodward will then move to enter exhibits into evidence, and then we'll take comments from the public on sections of the proposed rules that they would like to comment on. I would remind those giving comments today that this hearing is being recorded, and before you speak, please state for the record your full name, and if you are appearing on behalf of some entity, to indicate who you represent. The department is not bound by the formal rules of evidence during these proceedings. However, the hearing officer may, in his discretion, exclude evidence that is incompetent, irrelevant, immaterial, or unduly repetitious. The hearing officer may also take notice of judicially cognizable technical or scientific facts within the department's specialized knowledge. This is the public's opportunity to offer public comment. The hearing is intended to provide the public with an opportunity to voice opinions on the proposed rule. To be clear, this hearing is an opportunity for testimony and comments to be presented by those who wish to provide public comment on the proposed rules. It is not going to be conducted as a question and answer session. And if you have questions regarding the proposed rules, you are certainly free to include those questions in your public comment. The department will respond to your public comments at the time the department issues its concise explanatory statement regarding all comments received. The department will not be responding individually to those making comments on the proposed rule, but the department will publish a concise explanatory statement responding to all comments provided by the public at a later time, in keeping with the requirements of NMSA 1.24.25. And public comments will have a time limit of 5 minutes today, and Ms. Sundberg will keep us on track with that. At this time, I'd like to ask Mr. Woodward to introduce the exhibits and move to place them into evidence.
Yes, thank you. Good morning. So the department has several exhibits for today's rule hearing, and I'll note that these are posted on the Department of Health's website as well as on the State Sunshine portal. So anyone following along, if you're interested in reading through any of these are posted online. The first exhibit is the proposed amendment to Department Rule 7.34.2.7 NMAC. The second exhibit is the proposed amendment, or I should say amendments to various sections of 7.34.3 NMAC. The third exhibit is the proposed amendment to 7.34.4.28 NMAC. The fourth exhibit is the notice of public hearing that was issued for today's rule hearing. This was published in the Albuquerque Journal and in the New Mexico Register in accordance with the State Rules Act. The fifth exhibit is the affidavit of notice to the public, which just lays out the steps that the Department of Health has taken to comply with the notice requirements of the law. The sixth exhibit is an affidavit from the Albuquerque Journal attesting to the publication of the notice in the Albuquerque Journal. The seventh exhibit is an affidavit of publication in the New Mexico Register. The eighth exhibit is the letter appointing the hearing officer for this rulemaking. The ninth exhibit is a decision by the acting Cabinet Secretary David Scrace on the recommendations of the Medical Cannabis Advisory Board, I believe from their last hearing, actually a couple of reports, I believe. And so within that, there are portions of that decision by Dr. Scrace that pertain to today's rulemaking, particularly with regard to the adequate supply limit and the proposed increase of that limit in the Department of Health's rule. The 10th exhibit consists of public comments, written public comments received by the Department of Health. And I believe we have received at least one written comment, and so that is within Exhibit 10. And the department would also request that the hearing officer leave the record in this rulemaking open following today's hearing for the receipt of the report, the next report from the Medical Cannabis Advisory Board. The Medical Cannabis Advisory Board will be meeting on December 7th, and as part of their hearing, they will be reviewing these proposed rules and making a recommendation concerning them. So we would just ask that the hearing officer leave the record open for the receipt of that report following their December 7th hearing, and perhaps that could be included as Exhibit 11. And with that, the department moves the admission of these exhibits into the rulemaking record.
The exhibits 1 through 10 will be admitted, and the request that we leave the record open for purposes of the report of the Medical Cannabis Advisory Board will also be allowed, and that will be Exhibit 11. And I think at this point we can turn to Dr. Zerlo for an introduction to the rules. Good morning, Dr. Zerlo.
Good morning, Mr. Erickson, and thank you. And thank you to everybody who is participating in this hearing today. We appreciate it and look forward to your comments and participation. So the proposed rules really cover several different sections of the current rules and regulations for the medical cannabis program within the Department of Health. I'm going to just go over the primary changes that are being requested in these rules. The first one is the amendment section in 734.2.7 and 734.3.7 NMAC. And these primarily are revisions that have resulted as the Cannabis Regulation Act has been instituted and has started to be in action. And this includes doing things such as removing definitions for items like courier, changing definitions for licensed nonprofit producer to licensee, and moving forward with several other amendments to those various definitions for the rules. In Amendment 734.3.9 NMAC, or Amendment 2 7.34.3.9, this is one of the primary changes for the rule, and it consists of an increase in the limit for adequate supply and the removal of the medical exception that currently exists for the program. The amendment in this section also includes new text to explain the significance of the limit in light of the changes in the law resulting from the enactment of the Cannabis Regulation Act. This also fits in with the recommendation from the Medical Cannabis Advisory Board, which requested, upon a petition from the public, had a request to increase the adequate supply to 420 units. The department has changed this to be mathematically closer to 15 ounces, which was also included in the petition, and is so looking to amend this portion to 425 units, which is closer to the 15 ounces recommended by the Medical Advisory Board when converted into the unit system for the program. Section 10 does include an amendment to remove the caregiver background check. And again, this is to adjust for the new criteria within the Cannabis Regulation Act, specifically with regard to expungement in criminal records for caregivers and for individuals in the possession of cannabis. The next couple of sections, again, simply include items that are either replacement of references with regard to producers or changes to some of the items that the Cannabis Regulation Act now transferred to authority within the Cannabis Control Division. For example, laboratories, and again, changing the definition of producer to licensee. In section 734.3.19, this amendment actually includes the references to reciprocal participants in order to be able to, once again, have revisions that are consistent with the transfer of the licensing authority to the Cannabis Control Division. The addition of the new section 734.22 NMAC essentially duplicates the current reciprocity provisions that are included in the rule 734.4.28, but it is revised to reflect the increase in the reciprocal limit, which is consistent with the adequate supply limit for patients at 425 units or 15 ounces. And then the final major change is the removal of the existing rule of 7.34.4.28, which was the old version for the reciprocity provisions and will now be included within 7.34.3.22. And again, all of these changes, or the majority of these changes, are in response to the new Cannabis Regulation Act and the changes in duties and responsibilities from the New Mexico Department of Health to the Cannabis Control Division at the Regulation and Licensing Department, especially with regard to cultivation, production, and sale of cannabis. The other change with regard to the unit and adequate supply limit has been done upon review of this by the Medical Advisory Board after petition by the public, by a member of the public. And those are the major revisions. Do you have any questions, Mr. Erickson?
I do not. Thank you for your introduction.
Thank you, sir.
And I believe we're ready now to take public comments. Ms. Sundberg, will you call the first individual? Well, let me ask, has anybody indicated that they would like to make a public comment?
They have not, and just to let participants know, if you would like to make a public comment, click on participants in the lower right-hand corner, and next to your name, you'll see a little hand. Just raise your hand and we will call on you. For those of you that are on the phone, I will state the last two digits of your phone number. and to give you the opportunity to speak as well. If you do not want to speak, you do not have to respond. We do have one person that has raised their hand. That is Christina Caffrey. And Ms. Caffrey, you are unmuted.
Thank
Good
you.
morning.
Good morning. I
Ms.
want to
Caffrey.
read from the Cannabis Regulation Act, and I will read several sections of the statute that show why any attempt by DOH to promulgate a patient purchase limitation is blatantly illegal. The DOH has no authority to do what it is trying to do today. First, section 26-2C-5. It says, except for administration of the Medical Cannabis Registry, the power, duty, and authority of the Department of Health related to the Medical Cannabis Program shall be transferred to the division on the effective date of the Cannabis Regulation Act. And the division there refers to the Cannabis Control Division within the Regulation and Licensing Department. Second, section 70 of the Cannabis Regulation Act reads, to the extent any administrative rules are inconsistent with the provisions of this act, such rules are null and void. Third, section 26-2C-25A1 reads, the following conduct is lawful for a person who is 21 years of age or older and shall not constitute grounds for detention, search, or arrest of a person possessing, using, being under the influence of, displaying, purchasing, obtaining, or transporting not more cannabis than authorized by the Cannabis Regulation Act. Fourth, section 26-2C-3B4A directs the Cannabis Control Division within RLD to promulgate rules stating that, quote, a person who is 21 years old or older shall not purchase more than 2 ounces of cannabis, 16 grams of cannabis extract, and 800 milligrams of edible cannabis at one time. Finally, section 26-2C-6K. As to activity under the Medical Cannabis Program, the licensee shall continue to operate under rules promulgated for the Medical Cannabis Program until the division, again, that's the Cannabis Control Division, promulgates rules for medical cannabis activity, except that a qualified patient, a primary caregiver, and a reciprocal participant shall not be prohibited from purchasing and obtaining cannabis products pursuant to the Medical Cannabis Program. All of those sections indicate and demonstrate that the DOH has no statutory authority to promulgate any regulation that limits the amount of cannabis that a medical cannabis patient can purchase. The purchase limits are now enshrined in statute in the Cannabis Regulation Act. Thank you.
Thank you, Ms. Caffrey. Has anyone else indicated a desire to speak today?
At this point, we do not have anybody else indicated. For those of you that are on the phone, if the person whose phone number ends in 64 would like to speak, now is your opportunity. Okay, and for the person ending in 00, this is your opportunity to speak if you would like to speak.
Yes, Andrea, this is Duke Rodriguez with Ultra Health. I'd like to make a comment, please.
Good morning, Mr. Rodriguez.
Good morning, Mr. Rodriguez. You are all set.
Thank you very much. It is embarrassing that we are participating in this rulemaking instead of waiting for the courts to properly adjudicate this issue. The Cannabis Regulation Act specifically states that any person may purchase 2 ounces of cannabis, 16 grams of cannabis extract, and 800 milligrams of edible cannabis at any one time as of June 29, 21. This matter has been fully briefed and sits before Judge Ben Chavez awaiting his ruling. On June 29th, DOH was fully stripped of any regulatory powers besides the patient registry. It is inappropriate for an agency that has been stripped of its powers to propose a rule to limit patient purchases below their statutory right, acting as if they are above the law and the legislature. The level of misinformation is frightening. The intentional misrepresentations about the price and availability of cannabis communicate to both the general public and the New Mexico legislature are shameful beyond comprehension. Why is DOH as the illegal gatekeeper between patients and their medicine? These rules are punitive for patients and not in accordance with law, and this rulemaking should be closed indefinitely. Thank you for the opportunity to comment.
Thank you, Mr. Rodriguez.
Thank you, Mr. Rodriguez. Next up, we have L. Candelario.
Good morning,
Mr.
Mr.
Candelario,
Candelario.
you're unmuted. Oops.
Hi, good morning. Can you hear me?
Yes, we can hear you.
Okay, thank you. I was having an issue there.
No worries. Thank you.
So, I've had a 10-year career in the medical cannabis industry, and I wanted to offer some on the ground perspective. So, I think all of these rule changes are very important and will impact the lives of our community, but for brevity's sake, with respect to the amount of cannabis that our patients have access to, safe and legal access to, a lot of our patients that are in special populations need access to larger amounts of flower in order to make medicine for themselves. It's not just these people, puff and tough. A lot of our patients can't tolerate smoking, and right now the access that they have just is not working. And I just really wanted to offer that perspective of patients who, have been asking for this access to more quantity of their medicine and really need it. So thank you for this opportunity.
Thank you, Ms.
Thank you, ma'am. And
Candelario.
I don't know if we caught your name on the record. Could you please state your name?
Oh yes, my name is Alessandra Candelario.
Thank you very much, ma'am. I appreciate it. Okay, next up we have TJ Trujillo. Mr. Trujillo, you are unmuted.
Thank you. Can you hear me?
Yes, sir, we can hear you. Thank you.
My name is TJ Trujillo. I am an attorney for Pecos Valley Production. In order to keep my comments brief, I'll simply say that we concur with the comments by Ms. Caffrey and Mr. Rodriguez regarding the fact that this rulemaking is contrary to law and should be terminated. Thank you.
Thank you, Mr. Trujillo.
Thank you. Okay, I see nobody else with their hand raised. If anybody else would like to make public comment at this time, please raise your hand. Nobody else has raised their hand, and just as a reminder, public comment period will be open. You can still submit written comment to the website or to the email address mcp.comment@state.nm.us until the end of this hearing. Okay, one last call. Anybody that would like to make public comment, please raise your hand now. Okay, Mr. Erickson, I see nobody else with their hand raised that would like to make public comment.
Thank you, Ms. Sundberg.
You are very welcome, sir.
Well, with that, let me just make a couple of comments. My job at this point is to produce a report and recommendations to the acting secretary. I anticipate doing that early in January of 2022 after we get the additional submission that we anticipate in mid-December. And I would like to thank you all for participating today. And unless there's something further from you, Mr. Woodward, I believe we'll close the hearing.
Nothing further here. Thank you.
Okay. All right. We can go off the record. I'd like to, Ms. Sundberg, please leave the platform open for a couple of minutes. I want to make sure I have all the participants that are listed before we shut that down.
Yes, sir.
All right.